My name's Derek Hollingsworth. I'm the president of the Federal Bar Association for the Southern District. As you know, we put on monthly CLE events, annual dinners, which we were talking about earlier. But we put on monthly CLE events just like this one, where it's an opportunity for our FBA members and maybe hopefully people who want to become FBA members to come get together, break bread together, and listen to interesting speakers and get CLE credit. So today is no exception. We do this every month. So if this is your first time here, or you're not as frequent of a flyer as some of our other participants, then just know that we do this every month. And if you're not a member of the Federal Bar Association, it's a really easy thing to join, and it doesn't cost much, and you get a lot of bang for your buck. So if you're interested in joining, we have a website. You can ask me, you can ask questions, and we'd love to have you as a member. We do lots of great things beyond just monthly CLEs. So our reach is through the entire Southern District of Texas. So please think about that. Please join. I just wanted to say hello, and I'm going to ask Tony Cavender, who's on our board and actually does all the hard work to put on our monthly CLEs, to introduce our speaker, and I hope you enjoy. Tony, thanks.
Thank you, Derek. Please, I haven't said anything. It is my great honor to introduce Professor Josh Blackman. Professor Blackman went to George Mason University School of Law.
That's right.
It has been renamed.
It is now the Antonin Scalia Law School. No new diploma, though. Same old diploma.
Same old diploma?
No new diploma.
That's the originalist part of law.
I actually put a Post-it note on my diploma saying Scalia. That's how I made it work.
Professor Blackman is Professor of Law, South Texas College of Law, specialized in constitutional law, the United States Supreme Court, the intersection of law and technology, and I think he has a roving commission.
A roving commission. Uh-oh.
That was the title of Churchill's memoirs. A roving commission throughout the law. So I think you'll really enjoy this presentation. Last year, he took us through the intricacies of the passage of the Affordable Care Act.
That's right, I did.
And if anybody can make the Affordable Care Act interesting, is Professor Blackman. So you got a hard act to follow. This year is the 150th anniversary of the 14th Amendment. And I thought it would be great to have a presentation about this at this time, because it's one of the amendments that is so important to so many people. And I've asked Professor Blackman to speak on that to us. So thank you, sir.
Thank you so much. Thank you all. Thank you so much. It's a pleasure to be here. I see several of my former students from the South Texas College of Law here. Now they're attorneys, they're adults. It makes me very happy to see them in the wild. This year, 2018, is the 150th anniversary of the 14th Amendment. You wouldn't know it, right? There's no bicentennial commission, right? There's no sesquicentennial commission. There's no fireworks, no displays. But we have two foundings in our republic. We had the founding in 1787, where our Constitution was drafted, and we had the second founding in the 1860s, when the Reconstruction Amendments were ratified, the 13th, 14th, and 15th Amendments. My talk today will focus on two of those, the 13th and the 14th Amendments. They have to be understood together. You cannot disentangle them. I will not be talking about the 15th Amendment, but I'll welcome any questions about it later. So to understand the 13th and 14th Amendments, we have to trace their origins from the Constitutional Convention in 1787 to Dred Scott versus Sanford in 1857 to the Reconstruction period immediately following the Civil War. And the starting point is a provision of the Constitution you probably never heard of. Article 4, Section 2, the Privileges and Immunities Clause. It provides, the citizens of each state shall be entitled to all privileges and immunities of citizens in several states. This provision prohibits states from discriminating against citizens from other states. Fairly straightforward. Specifically, a state must guarantee certain fundamental rights, known as privileges and immunities, equally to its own citizens and to citizens of other states. But what are these rights? What are these privileges and immunities? During the early years of the Republic, the circuit case of Corfield versus Coriel, 1823, was viewed as the most important judicial interpretation of this provision. Now, Corfield was written by Justice Bushrod Washington. He was President George Washington's nephew and a justice of the Supreme Court. And he wrote this opinion while riding circuit from the District of Columbia to the District of Pennsylvania. Justice Washington explained that this clause protects those privileges and immunities which are fundamental, which belong of right to the citizens of all free governments. In a lengthy passage of his opinion, Washington listed several examples of the privileges and immunities, including the protection by the government and the right to acquire or possess property of every kind and to pursue and obtain happiness and safety. He didn't make this formulation up. In fact, he got it in 1776 from George Mason, the namesake of my alma mater. Everyone knows Thomas Jefferson, but most people don't know George Mason. Mason wrote the Virginia Declaration of Rights, which preceded the Declaration of Independence by about a month or so. Mason referred to rights as, quote, inherent natural rights. Mason's declaration inspired Thomas Jefferson to write his declaration a few weeks later. Now, this concept of natural rights doesn't get much play today, but they were very important at the time of the founding. In fact, in 1783, the Massachusetts Supreme Judicial Court, their high court, invoked this sort of language, told that slavery was unconstitutional in that Commonwealth. These were very important legal concepts of the founding. And in the 19th century, this played an even bigger role. Free black sailors who were imprisoned in southern states while their ships were in port. The abolitionists like Frederick Douglass argued that they were citizens. And because they were citizens, they were protected by the Privileges and Immunities Clause. Therefore, the southern states could not imprison them. They had the same rights throughout the United States. You need to understand this clause because this is what gave rise to the Dred Scott decision. Most people know Dred Scott saying that it held slavery was constitutional, but it was actually primarily a case about citizenship. Diversity citizenship, that is, if you're a citizen of one state, can you sue a person of another state? But also, if you're a citizen, you get these privileges and immunities. And by virtue of its existence, if you have these rights, you cannot be held as a slave. This is why Chief Justice Taney in Dred Scott had to go so far out of his way to hold that people of African descent could never be citizens. If they were citizens, they get these privileges and immunities. And Taney couldn't handle such a concept. He even said that if it was understood that people of African descent could get these privileges and immunities, that the states would have never joined the Union, that the southern states would have never joined the Republic if that meant giving the slaves certain rights. And what were these privileges and immunities? Taney says the full liberty of speech in public and the right to keep and bear arms wherever they want. These, you might think, are overlapping the First Amendment. So at the time of Reconstruction, right, when the Civil War was winding down, these rights, these privileges and immunities, were what separated a free person from an enslaved person. This is a very important concept. Now, we know Dred Scott was never actually overturned by the Supreme Court. Indeed, that decision invalidated the Missouri Compromise, which had tried to maintain a delicate balance between North and South. Taney's grand plan did not work. And in fact, his opinion, Dred Scott, helped precipitate a bloody Civil War, which began just 4 years later. And it was that Civil War that led to the repudiation of Dred Scott. Fast forward to April of 1865. General Robert E. Lee surrendered to Union General Ulysses S. Grant, which marked the formal cessation of hostilities. But that didn't end the struggle. That triggered the beginning of a process known as Reconstruction. At the time, the southern states basically had no representation in Congress. They were all sent back. So the only people voting in Congress were the northern states, which at the time was all Republicans. This was the party of Lincoln. And the so-called radical Republicans passed a number of bills and laws designed to eradicate slavery and also protect the freedmen. The most important of these was the 13th Amendment. It was ratified in 1865. Section 1 of the 13th Amendment provides neither slavery nor involuntary servitude, except as a punishment for crime, where the party shall have been duly convicted, shall exist within the United States. Now, just focus on that language. To date, every provision of the Constitution controlled government. Congress can't do this. The states can't do that. But the 13th Amendment acted on everyone. To this day, it is unconstitutional to hold a slave. To this day, it is a private constitutional cause of action, which doesn't exist. There might be another one with a prohibition of alcohol if you transport alcohol, not very important, but this is the biggie. It's unconstitutional for a private citizen to hold another as a slave. And Section 1 did what President Lincoln's Emancipation Proclamation could not. It eradicated slavery nationwide. Now, the framers of the 13th Amendment were not stupid. They knew that the southern states could not be trusted to voluntarily eradicate slavery. Now, let's be real here. They knew this wasn't going to work. So they added an enforcement power. Section 2 of the 13th Amendment gave Congress the power to enforce this article, that is Section 1, by appropriate legislation. What does that mean? Congress can pass statutes to make sure that slavery, in fact, is being eradicated. And if the southern states get in the way of that, Congress can enforce it by civil or criminal penalties. Okay? So one of the first laws passed after the 13th Amendment was the very famous Civil Rights Act of 1866. This was a monumental piece of legislation, the Civil Rights Act of 1866. The law provided, quote, that all persons born in the United States were citizens of the United States. What were they trying to do there? Overrule Dred Scott. Dred Scott said people of African descent could never be citizens, whether free or slave. Section 1, actually not Section 1, but the first part of the Civil Rights Act said, if you were born here, you're a citizen. Now we know from common law, can Congress overrule a Supreme Court decision by statute? Ugh. Don't you need an amendment to overturn a Supreme Court decision, even one you think is wrong? So at the time, people thought that this statute was very shaky, right? Could Congress actually overturn Dred Scott by statute? By that time, Lincoln had been assassinated, and President Andrew Johnson, who was a Southerner from Tennessee and a sympathizer, or maybe an opponent of Reconstruction, I'll leave it there. He was an opponent of Reconstruction. He vetoed the bill, and he said this is not constitutional. Congress overrode his veto, but they recognize it's very tricky to rely on a mere statute to protect citizenship, because the statute could be repealed. If the southern states rejoin the Union in the future, that Civil Rights Act may not be on sound footing. The Civil Rights Act did more than just grant citizenship to the freedmen. It also said that citizens of every race and color shall have the same right to make and enforce contracts, to sue, be parties, and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to the full and equal benefit of all laws and proceedings for the security of person and property. Not only did these laws make the freedmen citizens, but it guaranteed them certain basic rights, which were often called privileges and immunities. Later that year, in 1866, Congress passed the Freedmen's Bureau Act. This was a very important piece of legislation. It created an administrative agency to advance the interests of the freedmen, and it required the president to protect the rights given to the freed slaves that were listed in the Civil Rights Act, including the right to bear arms. So between the Civil Rights Act of 1866 and the Freedmen's Bureau Act, Congress tried to legislate under the 13th Amendment citizenship and various rights for the freedmen. Now, I told you that President Johnson vetoed the Civil Rights Act. He also vetoed the Freedmen's Bureau Act. He claimed that these were unconstitutional and that the 13th Amendment was not enough to prohibit. The 13th Amendment was not adequate to justify these statutes. Now, the House overrode both vetoes, and they became laws, but there was a real concern that you can't hang something as important as citizenship on a statute. It just wasn't going to fly. As a result, the 14th Amendment came into being. It was ratified 2 years later in 1868. And I want to focus on Section 1 of the 14th Amendment. There are 4 provisions of Section 1. Let me read them to you. First, it repudiates Dred Scott expressly. It says, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That nuked Dred Scott. They were now citizens not only of the United States, but also citizens of the state they reside. The state could not deny them citizenship. And again, Section 1 tracks the Civil Rights Act of 1866. They both ensure that everyone born in the United States, including the freedmen, would be citizens. Okay, so first sentence nukes Dred Scott. That's how you return a case, not by a statute, but an amendment to the Constitution. The second element of Section 1 of the 14th Amendment is the Privileges or Immunities Clause. This language tracks the Privileges and Immunities Clause in Article 4. Now let's keep these straight. In Article 4 of the Constitution, it's privileges and immunities. In the 14th Amendment, it's privileges or immunities. How do you remember this? A, and comes first. It's in Article 4, privileges and immunities. Privileges or comes later. Why is there a difference? Grammar. The 14th Amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Because it's no, it can't be and. It's no privileges or no immunities. Because it's a negative, grammatically you have to have or, not and. That's the only difference. It makes no actual difference. But it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay? Now, unlike Article 4 in the Civil Rights Acts, the Privileges or Immunities Clause was not drafted as a non-discrimination provision. It prohibited flatly any abridgment of a citizen's privileges or immunities. This wording now barred 2 types of deprivations of fundamental rights. Laws that discriminated against some citizens, as well as laws that discriminated against everyone equally. Indeed, the phrase, no state shall, sounds familiar, right? Is identical to the phrasing used in Article 1, Section 10. It's also very similar to the First Amendment. Congress shall make no law. This was a very strong prohibition on states making laws that violate these basic rights. Now, what are these rights? If you read through the debates of the ratification of the 14th Amendment, one source keeps coming up. For example, Senator Jacob Howard of Michigan was the amendment's sponsor. He gave a very important speech on the floor of the Senate. And he explained what are these privileges and immunities. He read from Justice Bushrod Washington's opinion in Corfeld versus Coryell. He created a direct link between those rights in Article 4, identified by Justice Washington 7 years earlier, and actually 50 years earlier, and those rights in this new provision. They understood that these privileges or immunities were these basic rights that were regarded since time immemorial as what free government should provide their people. He also linked it back to George Mason and the formulation of rights and the Declaration of Rights in Virginia. But there was a second category of rights he referenced, right? It wasn't just these sort of natural rights. He also referenced the first 8 amendments of the Constitution. The right to free speech, protection against searches and seizures, the right to bear arms. These were the sorts of rights that the federal government can't violate, and now the state governments can't violate. Before the 14th Amendment, the states could violate the Bill of Rights with impunity. Barron versus Baltimore, right? But after the 14th Amendment, at least per their design, the states could not do that. Now, it would take some time for the Supreme Court to get around to that. It would take them decades and decades, and they screwed up eventually by using the Due Process Clause. But the correct route by which the Bill of Rights applies to the state is not the Due Process Clause. It's the Privileges or Immunities Clause. This is an easy one. There are lots of hard questions in the 14th Amendment. This one's actually not hard. Now, there was a case about 10 years ago called McDonald v. Chicago, which considered whether the right to bear arms should be applying to Chicago. Now, 4 justices said, of course it does. It's a matter of substantive due process. Even Justice Scalia, bless his soul, right, went along with the substantive due process. Only Justice Thomas was correct. He said, no, this is not due process. One of the privileges or immunities of citizenship is the right to bear arms. Correct. But the court would not go down that path. So, first off, the 14th Amendment overruled Dred Scott. The very next provision overrules Barron versus Baltimore. So now the state police power is constrained by the Bill of Rights. So this is very powerful stuff. They are overruling really basic tenets of American law in like 2 sentences. I mean, it's a big deal to do this. Senator Howard also said that a source for guidance is the Civil Rights Act of 1866. The very sorts of rights Congress tried protecting with the Civil Rights Act would be protected by the 14th Amendment, and because it was an amendment, it could not be overturned by statute. That you'd have to ratify and repeal an amendment to kill this. They were trying to insulate against a time when the southern states regained power, and they knew exactly what they're going to try to accomplish. But wait, there's more. I've only done 2 provisions. Next. The third provision of Section 1 of the 14th Amendment provides, nor shall any state deprive any person of life, liberty, or property without due process of law. We know the Fifth Amendment already prohibited the federal government from depriving a person of life, liberty, or property without due process of law. Now, under the 14th Amendment, states were subject to the same restriction. We'll talk about what due process means a bit later, but this imposed a new requirement on states. If they want to take away someone's liberty, they must be affording them what process is due. The fourth provision of the 14th Amendment provides, or of Section 1 at least, states cannot deny to any person within its jurisdiction the equal protection of the laws. Let's contrast the Equal Protection Clause with the Privileges or Immunities Clause. Which of these provisions prevents states from enacting discriminatory laws? According to modern Supreme Court precedent, it's Equal Protection Clause, right? States must pass laws that treat everyone equally. However, the text of the 14th Amendment makes the opposite conclusion. It's the Privileges or Immunities Clause that bars legislatures from making a law that abridges the rights of all citizens, as well as laws that abridge the rights of any group of citizens. Specifically, the Privileges or Immunities Clause prohibited 2 categories of legislative action: laws that deprive everyone equally of a fundamental right, and laws that protect the fundamental rights of some citizens, but not others. Now, this is going to blow your minds. The Equal Protection Clause had a very different purpose. Its text does not impose limitations on the enactment of legislation. Rather, equal protection of the law requires equal enforcement of the law. Right? The word protection means to protect. The states now had an affirmative duty to enforce the rights of all people, white and black, male and female. That is, the government had to protect them from both governmental and private deprivation of their constitutional rights, including the Privileges or Immunities Clause of citizens of the United States. The Ku Klux Klan was established the same year the 13th Amendment was ratified. What we now know as Section 1983 was the Ku Klux Klan Act. It was designed to protect people from violence. Indeed, in the Civil Rights Act of 1866, it mandated that all citizens were entitled to the full and equal benefit of all laws and proceedings for the security of persons and property. The federal government wanted to make sure people were kept safe from lynch mobs. This is a very important provision, which people don't appreciate quite how broad it was, as this meaning just has been lost to the sands of time. And again, the framers did not trust the states to comply with the 14th Amendment, with good reason, right? Jim Crow started real quick after the Civil War. So they added another enforcement power. Recall that Section 2 of the 13th Amendment gave Congress the power to enforce Section 1 of that provision. Likewise, Section 5 of the 14th Amendment gave Congress the power to enforce Sections 1 through 4 of the 14th Amendment. Congress could now enact appropriate legislation to protect a person's rights under the 14th and 13th Amendments. Now, today we think of the 14th Amendment as something for the courts. With all due respect to my friends in the Fifth Circuit, otherwise, that's not accurate. It was Congress who was in the driver's seat. Congress thought it would be the ones protecting civil rights, not the judiciary. Unsurprisingly, as we'll discuss, it was the court that fell down and invalidated Congress's Civil Rights Acts. Congress was trying to do their job, but the courts got in the way. So this sort of flips the narrative, right, that the courts are the ones protecting rights and Congress is getting in the way. It's actually the opposite. Eventually everything righted itself out. But it was Congress, through the enforcement powers, were designed to protect civil rights and equality following Reconstruction. Okay. But this didn't quite work out. The original Constitution was primarily designed to empower and constrain the federal governments, with a few exceptions. But after the Civil War, everything got flipped. Now state power was going to be controlled by Congress, and if they didn't get along, the judiciary could intervene. But shortly after the Civil War, Southern resistance to Reconstruction and racial equality exploded. The 13th and 14th Amendments expanded Congress's powers to protect citizens from their own states, right? These amendments also empower the federal courts to enforce these rights. The 13th and the 14th Amendments fundamentally changed the relationship between the federal government, the states, and their people. Or at least that was the plan. Not everyone agreed that such a great departure from the original constitutional design was a good idea. Over the following 3 decades, the Supreme Court resisted, the judicial resistance really early, the Supreme Court resisted this alteration to our federal system by narrowly construing each of the 3 critical provisions of the 14th Amendment. Now, everyone knows the case Plessy versus Ferguson. Of course, everyone knows Plessy. That was actually a far less important case than the ones I'm going to mention now. That was important, but by that time, things were already done. The important cases were ones you probably never heard of. The Slaughterhouse Cases, Bradwell versus Illinois, and United States versus Crookshank. These were cases which my students know, but most students probably never learn. These cases basically deleted the privileges or immunities clause in the 14th Amendment. So what was the Slaughterhouse case about? Butchers. New Orleans, right? Always New Orleans. New Orleans passed a law that shut down all private butchers. It said if you want to slaughter animals, come to this central location. It was a monopoly, right? It was giving a cartel to one firm in the city. All the other people, their businesses were shut down. Everyone, shut down your butcher shop. The butchers brought a lawsuit, and they argued that this violated their right to contract, which was protected by the 14th Amendment. Now again, I read this to you. The framers of the 14th Amendment understood that a right of contract was included in these privileges or immunities. The Supreme Court upheld the Louisiana law. They said the privileges or immunities clause only protects a fairly narrow subset of federal rights. For example, the government must protect you in the high seas. They must guarantee access to the sub-treasuries. Pretty insignificant stuff. I just spent 30 minutes explaining to you how important privileges or immunities was. This is what overturned Dred Scott. And in one decision, the Supreme Court said, nah, we're not going to be in this business. To this day, my friends, the privileges or immunities clause means nothing. It wasn't until Justice Thomas wrote the opinion McDonald that it got any attention. Next decision, decided the day after Slaughterhouse, called Bradwell versus Illinois. That case involved Myra Bradwell, a woman. And she said, I want to be a lawyer. She apprenticed under her husband, who was an attorney, and she tried to apply to the bar, to the state of Illinois. Illinois says, sorry, we can't admit women to the bar. Because of coverture, women can't make contracts. They're incompetent to make contracts if they're married. Therefore, you're denied entry. So Bradwell went to the Supreme Court, and she said, aha, I have a right to contract. I have a right to pursue my occupation. The Supreme Court turned away saying, no, no, no. Privileges or immunities only apply to this narrow set of rights. So you have the Butchers, you have Meyer Bradwell. The third case, which you've probably never heard of, was gruesome. United States versus Cruikshank. Who's ever heard of Cruikshank? Oh, good, a couple of you. Yeah, thank you. I'm glad some hands went up. This was an awful case. You think elections today are disputed? Not like this. There was an election for a sheriff in, I think it was a town in Louisiana. I'm drawing a blank. I think it's, I forget the county, but it's a town in Louisiana. And you had two parties. You had the Democrats, who were the whites, and then you had an African-American contingency, who were the Republicans. And there was a dispute of who won the election. And both candidates said, we won, right? They both claimed victory. Then it got violent. So the African-American group, the Republicans, basically went to the courthouse that we're going to hold up here. And the other party, the Democratic Party, the lynch mob, said, no, you're not. And they lit the courthouse on fire. And they burned most of those people alive. The ones who managed to escape were shot dead and dragged to the river. It was called the Colfax Massacre. If you just want to Google it later, the Colfax Massacre, it's grisly. And there actually are not photographs, but drawings of what this looked like. And it's heart-wrenching. So the federal prosecutor in Louisiana, the U.S. attorney, brought a civil rights action against the lynch mob, a guy named Cruikshank. He said, you deprive these freedmen of their right to bear arms, right? You deprive these freedmen of their rights. You deprive them of their privileges or immunities of citizenship, and we're suing you for it. The Supreme Court reversed the conviction. They said that the right to bear arms, the Bill of Rights, Second Amendment, doesn't apply to the states, and that state lynch mobs could deprive people of the right to bear arms. So in these three cases, which you probably never heard of, maybe some of you have, Slaughterhouse, Bradwell, and Cruikshank, the Supreme Court gutted Section 1 of the 14th Amendment. They just gutted it. These provisions had almost no vitality for decades to come. Not what you thought in law school, huh? But it gets worse. Congress also enacted more civil rights acts. We all know about the Civil Rights Act of 1964, right, LBJ, that you can't discriminate on the basis of race in certain public accommodations. You have Heart of Atlanta Motel, right, in the Ollie's Barbecue case, Catholic and McClung. You know these cases. You probably didn't know that Congress tried to prevent racial discrimination 90 years earlier. Maybe some of you knew. The Civil Rights Act of 1870, or is it 75? I don't know, blank, but 70 or 75, there were a couple of them. It made it a crime, not just a civil offense, a crime to exclude someone from a public accommodation on the basis of race. A crime. You'd be indicted. Not just a civil offense, no Title VII, no burden shifting. You went to jail. So there were a series of cases called the civil rights cases where you had businesses that turned away black customers. And again, this was not just in the South. There were theaters in New York and San Francisco, all over the country that were involved in this. Right? Racial segregation was not limited to the South. Their appeals they were convicted and appealed to the Supreme Court. The Supreme Court overturned their convictions. On what basis? They held that the Civil Rights Act was unconstitutional. Why? The states only had the power to prohibit state action. They couldn't prohibit private discrimination. So if you were discriminating in a place of business, you couldn't do it. Now, public accommodations were known as common carriers. It was a fairly good argument that Justice Harlan raised in his dissent, that these were in fact public establishments that the state could reach. But again, this case gutted Section 5 of the 14th Amendment. So they gutted the Privileges and Immunities Clause, and they killed Section 5. They weren't done yet. There's a very anti-SCOTUS talk, but it's okay. Then we get finally to Plessy versus Ferguson, right? By the time we get to Plessy, which everyone knows, the 14th Amendment was just a hollow shell of what it was. You know, it existed, but its heart was already cut out. And in Plessy versus Ferguson, you had a case with a segregated railroad. This was actually state action. This was actually state action. Congress could prohibit this, but the court said, no. The 14th Amendment allows the government to have separate but equal accommodations. It doesn't require equality. And again, Justice Harlan dissented. So these decisions, which, again, are very important, Slaughterhouse, Bradwell, Cruikshank, Civil Rights, Plessy, 5 or 6 cases, basically destroyed the 14th Amendment. They just put into disrepute. And moreover, these decisions enabled the rise of Jim Crow, the name used to describe the regime of state-sanctioned racial segregation and discrimination that pervaded throughout the South and indeed parts of the North. And critically, this legal regime was reinforced by private violence against African Americans. Notwithstanding the 13th and 14th Amendments, local law enforcement, state actors, people acting under the color of state law, refused to protect the civil rights of some of their people. That's what protection was about, protecting them equally. These decisions also inhibited the fight against public and private racial discrimination throughout the rest of the United States. It wasn't until the 1950s and 60s that Congress returned to the enterprise of passing civil rights acts. But because of these cases, they didn't rely on the 14th Amendment, which is the most logical place. Instead, they turned to the Commerce Clause, which I always find kind of insulting. You have this amendment about civil rights, and you're relying on saying, oh, the people are articles of commerce, or there's chattel. I always find it a very strange argument. It's not correct as well as Aboriginals, but it's a bizarre argument that a person, a family moving from one state to another, is an article of commerce. And it's a very strange argument. I don't like it. But that's the basis of the Court of Appellate. The better argument is Section 5. That's where you get it, right? You pass an amendment about guaranteeing rights. That's where you make this up. That's where you do it. Another change. The court gutted the Privileges or Immunities Clause, so the Supreme Court instead turned to the only remaining provision, the Due Process Clause. And they used the Due Process Clause to incorporate the Bill of Rights. As well, the court basically totally rewrote the Equal Protection Clause. And they made it say a lot of things that are very similar to what the Privileges or Immunities Clause would have done. So where we are today is more or less the right place, but for the wrong reasons, right? The court's correct in incorporating the Bill of Rights, but they did it through the Due Process Clause. And the court's correct in ensuring that you can't have segregation, but they did it through the Equal Protection Clause. So I'm not that troubled, because I think we more or less wound up in the right place, but the court had like a 50-year delay. And they did these other provisions that really aren't the right way of doing it. So the common law professor when he gets a little angry, but they wound up in the right place, even if it wasn't the correct path, I think, more or less. But keep this in mind, right? Even though the 14th Amendment hasn't been fulfilled in terms of its promise, it's still there in the text of the Constitution. And that's important. When you commit something to writing, that means people can call you on it when you're not doing it. Right? If you just don't say it, you can, slide by. But when you commit something to writing, and you can, put it in your pocket and hold it up and wave it around, you say, follow this. And that's a promise that I think has been kept and hopefully will continue to be kept for at least another 150 years if the Republic is still standing. Thank you all so much, and I welcome questions. Thank you.
Back here.
Oh, yes, Charles.
Josh, in terms of sponsorship of the 14th Amendment in Congress, I've always heard the name, I think it's John Bingham.
John Bingham, yeah.
It there, and you didn't mention him, but I don't know much background on him, but what do you know?
Oh, yeah, I can talk about Bingham for hours. He was a congressman from Ohio, and he was one of the lead drafters in the House on the Privileges or Immunities Clause. And John Bingham also made a very close connection between the Corfield v. Coriel decision from Justice Bushrod Washington and the 14th Amendment. There was surprising agreement on that one point, that the rights are being protected were the rights in the were the rights in the Civil Rights Act and in Corfield v. Coriel. John Bingham was a very bright guy, very smart man. They were also heavily involved in the impeachment of Andrew Johnson. This was also going on at the same time. And I don't quote me on this. I think Bingham might have been involved in helping draft the articles of impeachment, but I think I might just Google me on that for sure. But really bright guy. Judge?
I'll add one footnote about Andrew Johnson's impeachment. Do you know who represented him?
Oh, it was a former justice of the court.
And you know who that was?
Oh, you're going to tell me.
I don't, you're reminding me of a whole lot of stuff that I haven't dealt with, so don't feel bad about this. It was Benjamin Curtis.
That's right, and he resigned after Dred Scott.
Right.
That's it, yeah.
So he was the dissenter in Dred Scott, but he represented Andrew Johnson successfully in the impeachment trial.
This is why she's the judge. Yeah, and just one more coda. The Dred Scott decision, this is not well known, the opinion was originally so long that the reporter of decisions made Tawney shorten it. He basically said, there's too much bad stuff in here. And Justice Curtis, who was, again, as Judge Jones mentioned, one of the dissenters, he actually resigned from the bench in disgust. He was so angry at Tawney over the decision.
It's the only time anybody has resigned from the court as a matter of principle.
We should do it more often. And one other note about Dred Scott, originally Tawney didn't have the majority opinion. He originally had a concurring opinion. There was another opinion, was it John? I forget who it was. One of the other justices had a fairly narrow opinion on jurisdiction. It was, narrow, but it's fairly narrow. But the Tawney opinion became the majority, and that's what triggered this massive constitutional revolution. We could talk about Dred Scott for an hour also if you want. Catherine?
So Josh, you say you're not too troubled because we more or less ended up in the same place going through the due process clause of the 14th Amendment compared to the privileges and immunities clause. But if you read Corfield and you look at the list of what was considered the privileges and immunities there's a lot in there that's missing in how we understand today's rights, shall we say. So what do you do with that?
I take what I can get as a common law professor, right? There's a lot of things that I don't like. So Catherine's point's this, right? The court has relied on the Due Process Clause to protect the provisions of the Bill of Rights. Okay, so far so good. They protected certain aspects of racial equality. So far so good. But the court has basically ignored the rest of the Corfield rights, which involves the rights of property, contract, the right to bear arms. These are pretty important. And I've written at some length that the court should revisit this and consider the rights that are actually protected and not the penumbras and emanations that the court has manifested in the last 50 years, right? So, Catherine, your question is right on point. I wish the court would go back and say, yes, we are reinvigorating Corfield v. Coryell, but I think only Justice Thomas was willing to go at least half that far. Thank you for the question. Yes?
Do you feel that the concept of incorporation is under siege?
Why would it be under siege?
Well, I know that there's some conservative commentators that don't like the idea of incorporation through the due process.
Through the Due Process Clause, yeah. I think as a matter of history, Hugo Black was right. The entire idea that you can just incorporate one right at a time based on what seems fundamental is garbage, right? It's not real law. And the court's basically made it up. And the McDonald opinion, whoa, Justice Scalia, you didn't do the right thing there. But I think at least most originalists say that it's an easy case for the Privileges or Immunities Clause. One note, not all the provisions of the Bill of Rights can be incorporated. I'll blow your mind. The Establishment Clause says Congress should make no law respecting the establishment of religion. Today that means that Congress can't show preference one faith or another. That's not what it meant. The states had established churches. That provision meant that Congress can't mess with the state churches. So the Establishment Clause resists incorporation altogether. This is Justice Thomas's position. I think he's right. Akhil Maher makes also. There's no argument to the contrary other than just it's living whatever we want. But the Establishment Clause can't be incorporated. The Ninth Amendment, I don't think, can be incorporated. 10th Amendment can't be incorporated. Maybe one or two others. But almost all the Bill of Rights can be incorporated through the Privileges or Immunities Clause. Thank you. What else? Yes, sir.
The justices on the Supreme Court in the 1860s and 70s, were there still some of the Lincoln justices on the court because they've been during the Civil War? And they're still in the court?
Yes. Stephen Field was a Lincoln nom. Am I right in that? I think Field was a Lincoln nom, so he was still in the court. Might have been one or two others. Yeah, but let me actually take your question in a different direction. The 14th Amendment was ratified under very dubious circumstances. A number of the southern states were basically given a choice. You either ratify or you stay in Reconstruction. So the number of states needed to ratify the 14th Amendment, how you count it might be a little tricky. And I'm not joking about this one. There was a serious concern that in the Slaughterhouse Cases, the Supreme Court would say that the 14th Amendment was unconstitutional. What? There was a legitimate, Kurt Lash makes this point, there was a legitimate concern that the Supreme Court would say in Slaughterhouse that you didn't have the requisite number of states to ratify the amendment, there is no effect. That might have started a second Civil War. So in hindsight, given the alternative of a weakened PRI clause or a Civil War, maybe it wasn't that bad. Now again, this is a lot of speculation, and we don't know, but I don't know that the ratification of the 14th Amendment was kosher, right? You know, they took a lot of shortcuts, and they basically twisted arms saying, ratify this or else you'll stay in Reconstruction. In fact, you see these cases a lot. People who are the people think that they don't have to pay taxes, right? The tax cheats, they're always in federal court. They say, because the 14th Amendment was not ratified, I don't have to pay taxes. Okay, they're nuts. But there's a kernel of truth in their nutsness. There are a lot of pro se cases. These come through the courts. These people, are there fringes on the flag in this room? Oh no, you have to check. We're in an admiralty court now, I think, and on the 28th floor. Yeah, Charles.
At the beginning, you said you weren't going to address the 15th Amendment, but you took questions on it. So
Sure.
what's up with that?
Okay, let's talk about the 15th Amendment. So the 15th Amendment, I don't know, that's all. I went to a pop constitution, so you never know when you get a pop quiz on the 15th Amendment. It says, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Now, that was ratified a couple years later, 1870, just check my year, I think it's 2 years later. And believe it or not, for a brief period of time in the South, African Americans voted at a very high rate. And in fact, they sent members to Congress. Was it Hiram Revels? I think it was the first African American senator. Just Google me on that. I think it was Hiram Revels. And he had an African American senator from Mississippi, if you can imagine that, for a brief period. Then it went downhill very quickly. The states began enacting poll taxes and grandfather clauses and this whole litany of measures of disenfranchisement. But one historical footnote on the 15th Amendment is the suffragists. They were not happy. The suffragists worked hand in hand with the abolitionists for decades. The idea was, okay, when you guys get rights, we get our rights. There was such a big debate among the suffragists about whether women would be included in the 15th Amendment that there was a huge schism that formed between
the freedmen and the suffragists. But let me just add a coda to this. The 14th Amendment says that all persons have certain rights. It doesn't say men or women. So you had, I think it was Susan B. Anthony, who actually went to a federal court and said, give me a ballot, right? Give me a ballot, I want to vote. And they said, sorry, you can't. And so they actually cite Section 2 of the 14th Amendment, which you probably never read. But Section 2 of the 14th Amendment refers to male citizens who have the right to vote. This was actually the first reference to gender in the Constitution. Section 2 of the 14th Amendment refers to male citizens with the right to vote. And at the time they said, look, it says here male citizens, that means women can't vote. So there was a huge debate about this. One other note while I'm on the topic. Erwin Chemerinsky, our favorite professor at Berkeley now, wrote this op-ed saying, aha, under the Constitution, women can't be president because it's the pronoun he. Hey, Erwin. No. For centuries, in the English language, the pronoun he was gender neutral, and I can give you books upon books showing this. But moreover, the framers were actually fairly conscious about this. In certain state constitutions, it said men or males can run for office. In other states, it didn't say that. In New Jersey, at the time of the founding, women could vote. And instead of saying men, it said freeholders, right? The person who holds property. So the framers understood there are ways of excluding women, and they didn't do that. So the 15th Amendment was only for race, but I think women could still vote at the time, but they didn't get quite that far. But then you had the, what year was it? The 19th Amendment, 1923, just check me on the year, was ratified, which allowed women to have the right to vote. And then decades later, we have the right to vote to 18-year-olds. We can debate the wisdom of that move anytime. Okay, other questions? Is that it?
Thank you.
Thank you all so much. Appreciate it.
Thank you so much.
Thank you.
We have a gift on behalf of the Federal Bar Association. We
Thank
give
you.
our speakers. I hope
Thank
you
you so
enjoy
much.
it.
I will enjoy
Absolutely.
it. Thank you so much.
Absolutely.
And I welcome questions as well. Thank you so much.
Thank you for coming, and obviously feel free to ask questions, but we try to get out of here on time as well, so if you want to stick around and talk or ask questions, please do, but otherwise, enjoy your day, and I hope you'll come back another day.
Thank you.